B, and then C, requesting the representatives of the political parties to sign the declaration of presidential results form and so on. All that is provided for there. And that is what the witness is talking about. It's not an expression of opinion. It's an expression of what is required to be done.
That's not evidence.
It is an expression of what is required to be done, and evidence is then provided on the basis of that. So my Lord,
irrebuttable presumption.
My Lord,
yes,
I think that this witness is providing a basis for other statements that the witness makes. If your lordships are inclined to regard it as a matter of law and so on, and so forth,
because basically it's from the regulation 4410.
Yes,
basically.
Well, but my Lord, it goes beyond,
substantially.
It goes substantially. Substantially, yes. It is. Substantially, it is. But my Lord, the reason why it is relevant here is because there's been an indication that when they made challenges to certain forms in the context of what was going to happen in the collation process, those challenges were set aside. And I believe that that is the context in which the witness is pointing out, that they are being set aside in the manner that was done was not in accordance with this. I think that in the context of this witness statement, that is what the witness is doing. The witness is alluding to the requirements in order to show that what was done to them when they were so the witness is alluding to this in order to show that what was done to them when they queried collation results from the regional levels in paragraph 10, what was done to them was not in accordance with what the witness is saying is required in paragraph 12. Now, your lordships indeed can recognize that substantially this is in terms of what is in regulation 4410. The witness puts it in as a backdrop to what he is saying about what they were denied in the room. Now, my lords, there is in my notes, the next one is paragraph 15. So I take it that paragraphs 13 and 14.
Yeah, paragraph 15, he compares with a portion where both could not be authentic up to the latter part. He never attacked the whole of paragraph 15.
And not paragraphs 13 and 14 either.
Paragraph 13 and 14
right.
Are not in contention.
Yes, my lord.
Okay.
So, my lord, paragraph 15, both could not be authentic. My lord, respectfully, as I've indicated, paragraphs 13 and 14 of the answer of first respondent are clearly paragraphs to which this part of the witness statement ought to be referred. Because in those paragraphs, the first respondent actually says further that at each stage, the candidates or agents present are given a duplicate carbonized copy of the summary sheets, namely Form 8B, Form 10, and Form 12. So they're given, according to this, carbonized duplicate sheets. Then 14, first respondent asks that there is therefore one original of each summary sheet with as many carbonized duplicates as are issued by the officer in charge. So there is one. So in paragraph 15, having said in respect of the Eastern region, 2 separate summary sheets were sent to the EC strong room, the witness says both could not be authentic. I mean, that is a clear reference to the answer of the first respondent saying that there is only one original. So if you're given 2 documents in respect of the same region and there are differences between them, both cannot be authentic. The witness is stating that as a fact. And that is something that your lordships are going to have to consider in the context of whatever evidence if the first respondent in their testimony is able to explain how, in spite of what they themselves say about one original of each summary sheet, one original. They say so in paragraph 14. So if they can come and explain to this court how, in spite of that, the witness found himself presented with 2 separate summary sheets, and he says both could not be authentic. Only by getting the originals of these documents can there be a clarity on exactly which is the genuine form from the region. That is an important factual statement that the witness is making. You cannot have, according to even the first respondent's own paragraph 40, you cannot have more than one original. So how do you suddenly have 2 different things that are reflecting different numbers and so on? How do you have that? So in paragraph 15, what the witness is saying in the passage that they seek to have struck out is, in our respectful submission, entirely permissible. And my learned friend appears to have an impression that, we are just going back to rulings of this court and so on about authenticity and all that. And I think that we need to disabuse his mind of the fact that we know how to conduct our own case. And if we wanted to go back to the issues that were dealt with in your ruling on the request to produce documents, I think we know the processes by which we can contest that ruling. So it is not by any stretch of the imagination, it is not in this witness statement that we are going to go back to a ruling that your lordships have made about authenticity of documents. What is being put in here by a witness has nothing to do with the ruling that your lordships gave in respect of the application about authenticity of documents. In paragraph 16, again, your lordships will see that what the witness is actually saying in paragraph 16 is extremely pertinent to paragraph 38 of the first respondent's answer. Because the witness in paragraph 16 is saying, in respect of the Greater Accra region, we observed that the total votes given to the petitioner which is meant to be based on the sum of on the face of the regional summary sheets presented was less than his actual total. Well, that's a very important statement of fact. We also observed that the regional summary sheets published by the EC while the process was ongoing had different figures compared to the one given to us in the National Collation Center. And my lords, as I'm suggesting, if you look at paragraph 38, my lords, if you look at paragraph 38 of the first respondent's answer, it is quite clear that in respect of Greater Accra, there were a number of issues to which the witness is entitled to provide factual testimony. Say in paragraph 38, first respondent says that after the declaration of 9th December, which after the declaration of 9th December, 4 constituencies. So first respondent is trying to give an explanation, in effect, of some of the issues related to Greater Accra, about which, again, your lordships had a lot of cross-examination of petitioner's witness. First respondent here says, after the declaration of 9th December 2020, 4 constituencies in the Greater Accra region reported an update in the results announced in those constituencies, a net difference of 1,651. That update was factored into the 10th December 2020 press release, but it did not have a material effect on the overall result as declared. This is what the first respondent is seeking to provide by way of explanation. How can it not be permissible for the witness of the petitioner to give his account of the problems that they encountered in the strong room in relation to the collation? Because by this time, the declaration had not taken place. And so, whatever steps needed to be taken to ensure a proper collation, the witness for the petitioner and his colleague were seeking to have these matters addressed beforehand. And my lords, I mean, this makes his evidence even more germane in terms of the issues in this case, because the issues relate to the 9th of December declaration and the fact that effectively there is an admission by the first respondents that yes, there is an error in respect of what we stated to be total valid votes cast. That is their case. That yes, we admit that there is an error and we sought to correct it the next day. And they are providing in 38 further explanations of how they sought to make the corrections and so on. The witness of the petitioner is saying to this court what happened in respect of the very region where they acknowledge in paragraph 38 there was a problem, and saying that this is actually the fact. I think that testimony is directly relevant to the issues that are being addressed in paragraph 38. And if it were in a trial court proceeding, as I've indicated, one would directly put to the witness, this is the paragraph in which they are talking about Greater Accra. What do you have to say about that paragraph? And that witness will be entirely within the bounds of legal processes and evidence to then say exactly what the witness says in paragraph 16. This is what we observed about the total vote in Greater Accra. This is what was wrong. In paragraph 17, my understanding is that it's from the second sentence. Yes, that was one of the things in respect of which we asked the party headquarters to have the election directorate go back to the polling station level data to ascertain what the correct figures were. We were waiting to get feedback on that, among other things, when we had the declaration of results by the chairperson of the Electoral Commission. These are agents of the petitioner who were conducting their responsibilities under CIA 127 as they were duly meant to do. And they are indicating to the court how they conducted those responsibilities, not only as representatives of their party, but essentially as part of the nation's eyes and ears, and I guess hands and feet as well, in respect of this election. And they are saying that this difference, this particular difference between the regional summary sheet presented in the strong room and the one published on the EC's website has had no explanation provided for it. And that was one of the things in respect of which they asked. Now, my lords, in paragraph 41 of the first respondent's answer, they claim that in a bid to enhance transparency, they published the election summary sheets on their website. Now, my lords, this witness is saying there were inconsistencies that we found in respect of these things that you have now posted on your website. And you did not provide an appropriate explanation for them. So it does not enhance transparency if you publish things that you have arrived at in a non-transparent manner, and then you say it enhances transparency. You didn't allow these matters to be dealt with in the context in which they had to be dealt with. Then you are saying that after the event you publish those things and that enhances transparency. My lords, I cannot for the life of me understand how you fail at the point where you are required to be transparent and to engage these agents with the appropriate answer. You fail to do that, as is being alleged. And then you're saying that they can't come to court and say, these are matters on which I try to get the correct information in order to use to ensure that the transparent thing was done. Why can they not say to this court, that was one of the things in respect of which we asked the party headquarters to have the election directorate go back? Because, my lord, what is assembled and collated at the national level, as we have in fact heard many times in this court, comes from the polling station level. So if the witness is, again, drawing attention to what he sought to do, what he and his colleagues sought to do, in order to ensure that they could be effective participants in this process, I cannot see how that can be a basis for an objection to his. And my lords will notice that the witness says in the last sentence of paragraph 17, we were waiting to get feedback on that, among other things, when we heard the declaration of results by the chairperson of the Electoral Commission. We were waiting. So they've raised an issue. And in the interest of transparency, they're waiting for a response. And all they hear is that a declaration has been made. Now, my lord, I cannot see how, in a situation where the issue of transparency. The issue of transparency is being contested. In the lack of transparency is an issue here. I cannot see how the witness is not allowed in his witness statement to deal with this matter. Now, in respect of paragraph 18, there again, my lords, I think I will just abide by the response that I gave in respect of paragraph 15, because I think it is the same issue about authenticity and whether we are trying to go by the back door and so on. My lord, I always prefer to go by the front door. And I do not think that anything that we've done in this court in terms of the processes with which we have sought to address the court rulings suggests that if we are dissatisfied or if we want to confront a court ruling on authenticity.
This is the petition. We've taken notice of it.
No, my lord, this is a different paragraph, and I'm saying that I'm adopting what I said.
Yes, yes. So it's okay.
So this is a different paragraph. I have not addressed this paragraph.
No. What you said was that you were adopting your reply on the authenticity, which you copiously raising. Paragraph, I think, 15.
Now in paragraph 19, here again, the witness is talking about something that he did, which he found to be in error. There had been a complaint duly made. And maybe, my lords, again, I will take it with 20. I'll take it together with 20 so that, yes, I'll take it together with 20 to because both relate to this business about making a mistake and so on and so forth. And the witness is basically explaining the fact that there was something that he signed at this national level, and he missed the fact that at the regional level,
the summary sheet. Yeah, instead of the something that he claimed to have signed.
In 19,
yes.
When I signed the summary sheet,
that's right.
Yes,
that's right.
That's right. He said, at the time I signed, I missed the fact that the agents at the Regional Collation Center had stated clearly the reason for not signing. So, in other words, there was a reason given by the agent, again, in accordance with the rules. The agent actually gave a reason. And the witness is admitting that he missed that, and he signed. And they made the officials aware that the agents at the collation center had not signed and had given a reason. And so he says in paragraph 20, I would have pointed out my mistake to the chairperson of the EC if she had come for the process of assembling and collating results as she was required to do. So the witness is acknowledging an error and recognizing that there was going to be an opportunity for him to put forward the fact that there is a complaint. Let's deal with a complaint. That's what the witness is doing in this case. In any case, officials of the EC, being aware of the reason given on the form by the agent, could not just disregard it and claim that once I had signed, the matter was closed. My lord, if we were to be dealing with the fact that, or with the suggestion that once you sign a document, it is sacrosanct, I mean, frankly, we would have perhaps, had some very serious issues with all the changes and amendments and press releases and all that. But that is not the issue here. The issue here is that this witness is openly acknowledging, I missed something in the documentation. The EC officials knew that it was there. I missed it, and I would have brought it up if the opportunity arose. So we cannot see how that should be taken out. In paragraph 22, the witness states, it was in the light on the experiences. I'm sure that it must be off, but it was in the light on the experiences, what's there, of different regional certification processes and the posture of the EC officials in the strong room on 9th December 2020, that on behalf of my colleague and myself, I sought to consult with the chairperson of the EC, the returning officer herself. So, my Lord, he is testifying to why he sought to consult with the returning officer. And he goes on to explain that he needed to receive feedback on what he had conveyed to her the previous day. Particularly as I learned from officials at the NDC headquarters before I got to the EC headquarters on 9, that there was likely to be a stakeholder meeting of key players in the presidential elections with participation of local and international observers, media and civil society groups, and the EC to address concerns that the NDC addressed. Well, all this is evidence in respect of what matters had arisen in the strong room which he sought to take up, and which again provided the context of his meeting with the chairperson of the EC. This was testified to by Dr. Professor White. No objection was raised when it was testified to by Dr. Professor White. Is it that one of them has doctor before his name and the other doesn't have doctor? That cannot be a basis for legitimately objecting to Mr. Roger Metelnunu, Mr. Robert Joseph Metelnunu, testifying to matters which were accepted without objection when Dr. Professor White testified. There cannot be a basis legitimately. There cannot legally be a reason for the differentiation between what happened in respect of Dr. Professor White and what is now happening in respect of Mr. Metelnunu. My Lord, in paragraph 24, which is also being objected to, and my Lord, that is deceit. This was something about deceit. This was something about deceit, that we are talking about deceit. My Lords, in none of the paragraphs 24, 29, 30, 31 that my learned friend referred to, in none of those paragraphs is there any allegation of deceit. There are factual statements being made. Paragraph 24, the witness says, I was also struck by the fact that she proposed that she would send a dispatch rider to help us to get back to the headquarters of the EC ahead on time for her own exercise of her responsibilities. There was nothing in the discussions which could have given me any reason for doubting the word of the chairperson of the EC. Indeed, having worked with her previously when I was a consultant to the IEA, I had no reason not to trust her. No, I mean, this is not an allegation of deceit, it's just a fact. you know, I have no reason not to trust her. So when she said so and so, I did so and so. That cannot be an allegation of deceit. Now, my lords, we can draw inferences about deceit. Yes, we can draw inferences, but there's nothing in the witness statement where there is an allegation of deceit. And indeed, in the witness statement, as your lordship said, these are not pleadings. So it's not as if, you know, there's a pleading of deceit, and then there have to be particulars provided and so on. That's not the nature of what we're dealing with in this witness statement. My lords, again, it is significant that in the case of Dr. Kwesa White, he stated under cross-examination categorically that he felt they had been deceived. He did say that. Dr. Kwesa White said that. He stated that. He felt that they had been deceived. Now, and he stated that in response to questions in cross-examination. But what we are dealing with here, respectfully, is evidence in chief of this witness. And he has not made anything on the basis of which it could be said that some pleadings should be amended for further particulars. And my lords, I would want to respectfully submit that in 24 as well as, and my lords, obviously there is relevance in all this, and it is quite clear that it is the powerful relevance of all these statements that the witness is making in the witness statement, the powerful relevance of that the respondents are seeking to run away from. Because, my lords, it is powerfully relevant.
Please, the language is too tough in a court of law. They cannot run away from.
My lords,
no, please.
May I just, I will restate.
That's right.
I will restate the point that I want to make in the following manner. There is no doubt that the testimony that is contained in paragraph 24 is powerfully relevant to the issues in this case. There's no doubt about that. It's powerfully relevant to the issues in this case. And what my learned friends, in my respectful submission, what they need to address is whether those statements are true or false. And those are matters which will be dealt with in the context of the further proceedings in this court. So your lordships will have the opportunity to assess. You'll have the opportunity to assess whether what this witness is saying is truthful and therefore relevant in the powerful way that I'm suggesting to a determination of the matters before you. Now, my lords, again, in cross-examination, Dr. Kwesa White testified to these matters. There was a dispatch rider going to be sent and all that to help them get back to the place in time. Dr. Kwesa White has testified to these matters. without objection. Why are we confronted with an objection when it's Mr. Metalunu who is testifying? More. And below, we underline the fact that Dr. Professor White testified in cross-examination at their instance. So, not only did they not object, but they invited the answer. They wanted the truth on that occasion. They wanted the truth from Dr. Professor White. They said, what you're saying is not true. They put that to Dr. Professor White. And he then testified that this is true. He testified, why would I say this if we did this and that? We left our bags there and so on and so forth. Why would I? No. So all that was at their own invitation. Now we have a witness who is testifying to the same matters, and now they are objecting to this witness testifying it. And this is why I stress that this is not an objection based on the lack of personal knowledge. It's not. And in fact, in their cross-examination, they sought, again, to make an issue of the fact that Dr. Professor White is not the person who spoke directly to the chairperson of the Fed. They sought to make much of that. Here is a witness who spoke directly to her. Can his testimony not be taken? On what grounds? They did not object. They actually... Now, I move on to 25. And my lords, this is, again, extremely pertinent, extremely relevant. The witness says, I returned to the strong room after my meeting with the chairperson of the EC and made it known to those present, including to the observers and other presidential candidate representatives and the EC strong room coordinator, that we had been sent to convey a message to the NDC presidential candidate. My colleague and I only left the premises of the Electoral Commission at the instance of the chairperson of the Electoral Commission to go and meet with the petitioner. We had absolutely no other reason to leave. We left our belongings, including computers and bags, in the strong room at the time we left. My colleague left his vehicle at the premises of the EC. Now, Manu, what has this testimony, what has it got to do with allegations of deceit or whatever? We left. We returned to the strong room after the meeting. I, the one who went and spoke to the person, I told everybody in the place that this is what happened. And then he goes on in paragraph 26, which is also being sought to be struck out. Paragraph 26, he says, all of the above in paragraph 25, all this would not make sense if we did not intend to come back to the strong room. In fact, the second petitioner's witness also made similar statements. Why would he leave his stuff in there if he didn't intend to come back? And in the case of this particular witness, he says, he adds, again, a very pertinent, very relevant piece of information. He says, indeed, Mr. McMenu, who is representing the second respondent in this case, acknowledged in a television interview on Metro TV that he knew we were coming back, and said so to a colleague of ours who came to the strong room after we had left. Our colleague came specifically to give me a change of shirts I had requested for since we have been in the strong room from the evening of 7th December 2020. I attach here with a recording of that interview, marked Mark Menu. My Lord,
I think I heard him submitted that they were not on the basis that they were not supported by the pleadings.
my Lord,
If my notes
my Lord,
is right.
my Lord,
No, I just want you.
yes, to address,
Yes.
my Lord, I'm grateful for your guidance because indeed my notes do not sufficiently capture all the points. So he claims that these are irrelevant.
Was it not the point that you missed? My Lord, I said
They were irrelevant and further not based on the pleadings. Further.
So, my Lord, it was a double-barreled approach. And I think I dealt with the first barrel. I will deal with the second barrel. My Lords, to claim that these statements or this testimony of the witness is irrelevant, I think, my Lords, is difficult to appreciate. In a context where one, there is the evidence of Dr. Kwesawai already on record about the circumstances of their departure. That evidence is before you. And here's a witness who is not only corroborating that, but who is providing a further context of contemporaneous account, a contemporaneous account that is provided by the second respondent's representative. Well, my lords, as far as I can remember, admissions that are made by the other side are very important evidence when you are dealing especially with issues of credibility. Because if you are saying that this is what happened, counsel for first respondent cross-examination, it cannot have happened, it did not happen, you just sneaked away, you melted away, all kinds of words were used. The witness is saying that your second respondent's representative, he did an interview in which he acknowledged that was contemporaneous at that time. So there wouldn't be any lapses of memory or anything like that. He acknowledged that he knew that we were going to come back, and he boldly and truthfully, you know, and my Lord, we have to commend the truthfulness of Mr. McMenu.
at this stage,
Lord,
I think it goes to correct.
very well, very well, very well. I think that's about it. Well, I don't believe there was any other beyond 26. Right.
So those for 28.
Right. So we are left with 29, 30, and 31. And maybe I will take, yes, I will also lump them together. And my recollection is that this was not double-barreled, but this was related to deceit. That's why this is where he tied it to 24 and said that you have to read it in conjunction with, yes, 24 to be read with 29, 30, 31. That's what my notes say. And my lords, my simple submission in one lumped up sentence is that these paragraphs are relevant testimony about issues in this matter on which the respondents are contesting what petitioner is saying, and they have nothing to do with an allegation of deceit. I'm sorry if it's too long a sentence already. I'm sure the professors don't like long sentences, but very well, very well, very well. And my lords will see that on the clear terms of those paragraphs, yet my colleague and I realized with shock on our reaching the residence of the petitioner that the EC chairperson was in the process of announcing results. These are just statements of facts. 30. Petitioner naturally asked so and so, then testified to the fact that he made attempts to reach and so on. And in conclusion, 31, he says, I still cannot believe and so on and so forth. And my lord, this again is regarding the credibility of the evidence that he's giving. He says, I cannot believe that because so and so. And he goes back, and my lord, this is very significant in paragraph 31, if I may say so. He says that since 1992, I have personally represented the NDC and its respective flag bearers in the strong room for various presidential elections. I have always played my part honestly and in a principled manner in election processes in the country, regardless of my own preferences, and been part of election outcomes in which my candidate won and where my candidate lost. My lord, that is again a witness who is using his experience in order to help this court to arrive at the truth. Now, my lord, paragraph 32 is not objected to.
Yes,
oh, he's attacking paragraph. Okay, very well. So, my lord, I would respectfully just also underline the point that on many of these matters, evidence is already before you. And that evidence largely came out of cross-examination. That will be all.
Yes, on matters of law.
Yes, do you have any point of law to raise by way of reply?
Yes, my short reply is that we are in this position because of the magnanimity of the court that permitted the respondents to file their processes first before the petitioner.
No. You see, please. Is it a reply?
Yes, we also
point of law. Please. What happened was that they had discussions with you about the inability of this potential witness to give evidence.
No, my lord.
Yes.
No, they didn't have any discussions with us. My lords recall that when we came here on Wednesday,
yes,
I repeated exactly what you said, that they said they had a matter which they will come and discuss in court.
In chambers.
In chambers, sorry, my lords.
Yeah, but did they not discuss it with you?
No, my lords.
It wasn't mentioned.
No, my lords.
But this is not a reply. Oh, no. In fairness to the settled practice, this is not a reply. Yes, Mr.
My lords, I agree with my learned colleague on the other side that the rules under which petitions are brought do not make provision for reply, as he suggested. But that is the reason why, when you are filing your petition, you must put in all the relevant and material facts, because you know you will not have the opportunity of a reply. Now, my lords, all the paragraphs of the witness statement that we are taking objection to, in our view, relate to material facts, and there ought to have been a pleading of those facts in the petition. Then it will give the opportunity for them to elaborate those facts in their witness statement.
In fairness to the petitioners, you see, most of these depositions, arose out of the evidence of Dr. Pesar White.
But
equal examination.
But my lord, but my lord, that actually shows that this witness statement is an attempt to close the problems of Pesar White's cross-examination.
Mr. Silfi, please.
In fact, at the heart of this witness,
let's regulate that.
At the heart of this witness statement,
yes,
is an attempt after the fact to bolster or correct some of the problems with Dr. Pesar White's thing. But that was not.
No, was there no admission from Pesar White that he was there with this potential witness?
My lord, what we are saying is...
No. Yes, respond
yes,
to my question.
Yes, there was.
Yes.
But my lord, you notice that this witness would have given his evidence but for his sickness. But somehow, as soon as Dr. Pesar White finished his evidence in chief and was cross-examined, they brought him in. But that's beyond the point anyway. He got well. My lord, my main point is that these are major issues, and they ought, especially when the provisions under which petitions are brought do not make room for reply, they should have set those key issues. My lord, indeed, counsel has said in relation to paragraph 15, this is the word he used, these are material facts. That's what he said. When he was making, he forgot himself for that moment. He said, these are material facts that the court cannot ignore.
In some of their submissions,
yes,
the paragraphs did you not say that some of these paragraphs, they don't have any foundation in the petition?
Yes.
So it can be taken care of.
Yes.
It cannot be the subject of it.
Okay, my lord. So let me furthermore state. Two, in our view, significant statements of the law. First is that they are under an obligation as I indicated before, of the 11 Rule 12, that 12.1, subject to sub-rule 2. And my Lord, sub-rule 2 is for purposes of this matter irrelevant because it deals with car accidents or something of the sort. Every pleading shall contain the necessary particulars of any claim or defense or other matter pleaded, including but without limitation to the generality of the foregoing. And then it talks about misrepresentation, fraud, and so on. So we are saying
this is not pleading. We are not dealing with pleadings.
It's evidence.
There could have been formal application.
No,
you have some. Please bear with me. There could have been a formal application at your instance to seek the striking out of some of the paragraphs in the pleadings. We've gone beyond that.
Yes.
Evidence is being amassed. We are just assembling evidence for the determination of this case. And you drew attention to the fact that some of these paragraphs in the witness statements are not supported by the pleadings.
Yes.
That doesn't mean that you are attacking the pleading.
No.
There could be deficiencies in the pleadings, but that is normal. But that, you didn't attack the pleadings. So you cannot be referring us to
my Lord,
the laws as they stand on pleadings.
No, my Lord, yes. my point here is that for the petitioner to be able to say in his witness statement what we have in this witness statement, he must first point to paragraphs in his pleadings, and those paragraphs must provide particulars. If they don't, and then in their witness statement they throw these things at us because he claims it is relevant when it is not in his pleading, if the foundation is not in his pleading, it cannot be accepted. Especially when the rules require you to set your particulars. And my lords, we are not going to raise that.
Particulars are very, very limited.
Yes. No, my lords, the provision makes a general statement that subject to paragraph 2, every pleading, that's what it says. Before then it goes on to say that especially in these cases, fraud, misrepresentation and so on. But the general clause is that subject to paragraph 2, which deals with particulars of debt, expenses or damages, or those particulars exceed 3 pages and so on. But subject to that, every pleading must have the particulars. And we are saying that their pleadings do not have the particulars that would enable them to lead this evidence. And my lords, again, we refer your lordships to.
Please, have you noticed any of this in the pleading of the first respondent?
My lords, in the first place, he has referred to certain paragraphs in the pleadings as the basis. I'm saying that those paragraphs should have, if they are referable, they should have the particulars. Those paragraphs he referred to as giving him the foundation to lead this kind of evidence. If those paragraphs are actually relevant, they should have had particulars. That is the point we are making. There are no particulars. Please. Now, my lords, it's now going to be very difficult for me because it's a general thing. My lords, he refers to So, my lords, if you take, I believe, paragraph 23, which was one of them, the only particular referred to is that rather unusual way of exhibiting a document, Exhibit B. It has nothing to do with these matters. Yes, 23.
Yes.
Yes. Now, my lords, again, you refer to Article 296.
Oh, that's the constitutional provision.
Yes, but
about discretion, excess of discretion.
Yes, but he doesn't particularize. He's seeking to lead
the constitutional provision must be read as a whole. Yes. You don't have to particularize it.
No.
It must be read as a whole. If you are talking of Article 1, yes, and it is in contention, you read it as a whole to appreciate whatever meaning.
But my lords, having raised the matter of violation of Article 296, as part of his pleading, in my view, he ought to have particularized what exactly were the violations. Yes, precisely. Yes.
So what does Article 296? What does it say? It is talking about discretion, fair exercise of discretion.
Yes.
That is all.
Yes.
So you look at it in the context. You look at it. Yes. So no one.
My lords, again, that is all I can remember. My only final point is to refer your lordship. No, why not? I mentioned 23. I mentioned 24, which I think your lordships are not in agreement with. And I will my lords, I think my lords will see that there does not appear to be any pleading in respect of different summary sheets for the same region. There's nothing like that in his pleadings. There's not.
Ask any question about this Ayesu Ano.
My lord,
where they had two,
yes,
the second one sought to correct the first one.
Yes, my lord, I was then cross-examining Mr. Isiedun Ketia.
Yes.
And then I took him through his Exhibit D.
Yes.
And explained away Ayesu Ano, which was in his Exhibit E.
Yes.
Right.
Yes. But not Professor White. It was Mr. Isiedun Ketia, I remember.
That is so, it was Mr. Isiedun Ketia, not Professor White.
Yes. Now, well, that, as I said, I would like to refer your lordship to section 52A of the Evidence Act, which reads as follows. 52A of the Evidence Act. Yes, related to relevance, but the substantive thing is cumulative evidence. The court, in its discretion, may exclude relevant evidence if the probative value of the evidence is substantially outweighed by considerations of undue delay, a waste of time, or needless presentation of cumulative evidence. My Lord, the large portion of the paragraphs of the witness statement we are sought to attack involve cumulative evidence. Yes. The large part of the paragraphs, cumulative evidence in relation to what Dr. Pesa White, the evidence that Dr. Pesa White had already given. And then uses it to fill the gaps in Dr. Pesa White's evidence or testimony. My Lord, we are done.
Our ruling.
All rise.
we're supporting the new system. Yeah, we are mama bike.
But you are Tony near.
Let's not go be able to go in the
Because supporting my business for the new system. Hey, what's a Chevac t-shirt? Mato t-shirt. The power of Frank, I know. Your t-shirt will go, mommy.
Boss, champion, boss, Mr. Willie one.
Okay.
Thank you. I'm supporting the new system.
And your well-being.
Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency. Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency. Watch the Presidential Diary this and every Tuesday at 2 p.m. to 2:30 p.m. only on Net2 TV.
Net2 Television, beyond the limit.
Learning to read, reading to learn, learning to read, reading to learn.
Mama, I want to learn to read and write, to read to learn. Papa, I want to learn to read and write, to read to learn. I have a dream, and it's to be a better person. I have a dream, and it's to help my nation.
Learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn.
Susu.
Susu.
This is a Rebecca Foundation project to help children read and learn.
Showing every Saturday at 2 p.m. to 2:30 p.m. and repeated on Mondays at 6:30 to 7 p.m. on Net2 TV.
Log on to www.net2tvgh.com for your local news and politics, business, entertainment, sports, and news from around the world. Catch up with your favorite Net2 television, Oman FM and Ash FM shows on our website. Never miss an episode. Subscribe to our YouTube channel, Net2 TVGH, and hit the bell icon to get notifications when we upload new content. Interact with us and follow us on our pages on Facebook, Twitter, and Instagram at Net2 TVGH for amazing content right from your mobile phone or computer. Net2 TV, beyond the limit.
The economy, politics, sanitation, agriculture, education, join me Monday to Friday as we dialogue on issue-based politics, live on the Dialogue Show.
Watch the Dialogue Show from Monday to Friday at 7:30 a.m. to 9:20 a.m. only on Net2 TV. Net2 Television, beyond the limit.
Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Jama'a bayin Allah masu kallon mu, ni ne naku Abu Karim. Alhamdulillah. Lokaci ya kai zamu so makawa muku shirye-shirye a nan television Net2 in Allah ya yarda. Nan muna so mu gane wane ne Allah subhanahu wa ta'ala. Bayan wannan kuma mu gane menene Qur'ani. Bayan wannan kuma muna so mu gane wane ne Annabi Muhammad sallallahu alaihi wasallam. Bayan wannan kuma mun duba yaya za a yi in yi so yaranmu su gane Qur'ani. Bayan wannan kuma mun kawo muku shani siyasa. Bayan wannan kuma mu kawo muku batun abincin gargajiya na zango, yanda za a yi mu gane zama cikin zango in so zamantattayyar mu yayi kyau cikin zango. Ni ne naku Abu Karim. Wassalamu alaikum.
Watch Asrat every Wednesday 6 p.m. to 7 p.m. Repeats Thursday 6 p.m. to 7 p.m. only on Net2 TV. Net2 Television, beyond the limits.
Mama, I want to learn to read and write, to read to learn. Papa, I want to learn to read and write, to read to learn. I have a dream, and it's to be a better person. I have a dream, and it's to help my nation.
Learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn.
Susu.
Susu.
This is a Rebecca Foundation project to help children read and learn.
Showing every Saturday at 2 p.m. to 2:30 p.m. and repeated on Mondays at 6:30 to 7 p.m. on Net2 TV.
Log on to www.net2tvgh.com for your local news and politics, business, entertainment, sports, and news from around the world. Catch up with your favorite Net2 television, Oman FM and Ash FM shows on our website. Never miss an episode. Subscribe to our YouTube channel, Net2 TVGH, and hit the bell icon to get notifications when we upload new content. Interact with us and follow us on our pages on Facebook, Twitter, and Instagram at Net2 TVGH for amazing content right from your mobile phone or computer. Net2 TV, beyond the limit.